New digital products bring new challenges for consumers. Today, if your smartwatch is hacked or if you get harmed physically by your drone, it is difficult and expensive to identify and prove who's responsible for the damage. This is why the European Commission has proposed to review the Product Liability Directive that has been adopted nearly 40 years ago. There is a flourishing new generation of digital and artificial intelligence products that bring new opportunities, but also new safety risks. The specific characteristics of these products, such as complexity, autonomy, and opacity, may make it difficult or costly for victims to identify the liable person and to prove the requirements for a successful liability claim. Today, the victim of an accident involving a car has various options to file a complaint. A strict liability claim can be generally filed against the owner of the car, so against the person who takes out the motor vehicle liability insurance. A fault-based liability claim can also be filed against the driver whose action caused the damage. But what if the software of a car, such as the pre-collision system or adaptive cruise control, had a defect? For example, it didn't recognize an obstacle or it braked without reason, causing a crash. Then, a no-fault-based product liability should be available for the victim against the car manufacturer. So, what the proposal of the European Commission aims to do is to revamp that product liability regime and bring it up to speed with the digital age, circular economy, and the global value chains. It should make it easier for consumers who have been harmed by defective products to make claims and seek compensation. The definition of a product under the new proposal will now integrate software, including artificial intelligence system. The definition of damage would also be expanded, including corruption of data and recognized form of psychological injuries. The revised Product Liability Directive will also extend the 10-year liability period to 15 years for latent health injuries. The manufacturer's liability would carry on also after the product is placed on the market, including for software updates that are required to maintain safety. The new proposal would also alleviate the burden of proof on consumers for technical complex products for which it is usually difficult to prove the cause of the defect. When consumers are injured by unsafe products imported from outside the EU, they would also be able to turn to the importer or the manufacturer's EU representative for compensation. New technology is not good or evil in itself. It's all about how people choose to use it and how we can create the right regulatory framework to address its challenges without hampering innovation.